We will go on the record in the matter 25 CF44, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. Mr. English appears in person in custody with counsel Ryan Reed. We're set today in this matter for a sentencing portion of this case. Mr. English pled guilty to multiple counts, 37, 40, 43, 46, and 55. Multiple felony counts.
All right, this is a sentencing day, and it's not a minor case. We're talking multiple felony burglary counts, multiple victims, and a defendant already known to the court. And before anyone thinks this is just property, wait until you hear what the victims say about peace of mind, family memories, and sentimental loss that can't be bought back. Question is, does a prison sentence actually stop the cycle, or is this just the next chapter?
We are, before I move to sentencing, the court did not order a pre-sentence investigation report. Before we go to sentencing, we do have victim impact statements. Ms. Bauer, who will be the first to provide a statement?
MM are the initials.
MM, you can come have a seat over there at that black desk. If you would like to state your full name, you may. Otherwise, we will identify you as MM. All right, you may begin.
Thank you, Your Honor. First off, I'd like to say thank you to the Burnett County Sheriff's Department, the detectives that worked on the case, the district attorney's office, and countless of hours have probably gone into this case. And I just wanted to tell you I was appreciative. Your Honor, to be direct, I don't believe that the amount of time that's being offered is fitting for the crime. Mr. English and his associates, I don't know if I'm allowed to use the other people's names, so I won't, but they took more from me than just property. They took my peace of mind. They stole a piece of my childhood. I had one of the items taken was a 1979 Johnson 99 outboard motor that my father taught me how to operate a motorboat with. The previous summer, I'd spent rebuilding that thing from the ground up. And my plan for it the summer after it was taken was to paint it and put new decals on it and have it for my kids to enjoy for the next 30, 40 years. Gone. I owned an archery company in the Twin Cities for a while. I had a bow, a compound bow that was taken. That bow was made specifically for me. I mean, it's a one of a kind. I can't replace it. This is the third time that I've been a victim of theft in Burnett County. And frankly, I'm tired of it. It's got to stop. These people who are doing these thefts need to serve some serious time. And I don't feel that what's been offered is enough. I don't know what enough is, but I don't feel like 2 years is enough. He should be removed from society for a while longer than just 2 years. He's proven that he can't follow the laws that we all should live by. And frankly, it's annoying. It's tiring. I've been a victim twice in the home that we owned here. My parents bought that place in 1976. They're both gone now. The property ended up with me. The cabin we had there got destroyed in a storm. And that was hard. But I flipped the script and I was building a new house the year that Mr. English and the actorlings came in and took basically everything that I had been stockpiling there. So I had less to move when I came up in the spring. The scope of the theft from me is dramatic. I mean, I like I said, I had been piling things in my shed, anticipating building the new house in the spring. And I couldn't have hired a moving company to do a better job of taking everything. I mean, they literally took everything, left the riding lawnmower. I don't know why. Same with the camper. I mean, every compartment was taken, everything was taken. And I was sadly underinsured because I had added things to the shed that normally wouldn't have been there. It's just disheartening to know that these people, are so desperate that they have to break into someone's home and steal the items that they've worked hard their whole life to acquire. And I guess in closing would ask that he be given more time than what was presented by the district attorney. And that's about all I have to say.
Thank you,
Thank you.
Initials P.A.
PA. Have a seat. And then if you wish to state your full name, you may. If not, we will identify you as PA.
Thank you, Your Honor. Thank you for your time and for allowing me to have a voice here today. I'd like to first state to the court that as a Christian, I wish the defendant well and hope that this be but a low point in his life and that things continue only to improve for him from this point forward. My family, my wife and I bought the cabin in 2020, looking for a place for safety in the face of the riots, and as for a place that we could build happy family memories as my 4 kids grew up and started to move on. And we found that. We would spend weekends there as a family, kayaking, grilling, playing board games, disconnected from the electronics that drive us apart as family members day in and day out during daily living. We found a sense of peace at the cabin so profound that it never even occurred to me that I would need security cameras and gates at this place. However, I showed up one weekend and found the front door to my cabin smashed in, as well as the front door to my garage, and everything of value inside had been taken. Since then, we've spent thousands of dollars on security upgrades to the cabin and the property, internet subscription, which we didn't have before because we went there to disconnect. All in an effort to try and regain that sense of tranquility that we used to enjoy when we went there. But the reality is it will never be the same. It couldn't be. We used to go there to disconnect, and for all the happy memories we built there as a family in the past and all the memories we'll build there in the future, there's always going to be this black spot in the history of our cabin. My kids have 2 instances or events in their history that I know have imprinted themselves on my kids' brains, and it will stick with them for the rest of their lives. A rollover car accident from when they were younger, and the cabin being burglarized. Even now, when we show up, the kids ask me when we pull into the driveway, how do I know it hasn't been robbed again? And do I know it's safe to go inside? So I still have to clear the cabin before the kids will even go inside. I served a decade in the Marines. I'm on my 5th year as an officer in the Army National Guard. And I say that to highlight the fact that I've served with countless Marines and soldiers who've done a 4-year enlistment and then gone on to live lives as civilians after the fact. These are well-trained, well-educated, well-networked individuals, hardworking and law-abiding citizens. And many of them struggle to make that difficult transition from an organization with boundaries and systems in place to prevent failure to independent living, where every decision you make can have a profound impact on the quality of the rest of your life. If individuals like the ones I just described can struggle with that transition from organized living to individual living, I find it very difficult to believe that the defendant, given his lengthy criminal history and repeat offenses, is going to flip a switch while incarcerated and be able to make that transition to independent living and make meaningful, positive contributions to society. We say in the military that when things get difficult, you fall back on your training, you don't rise to the occasion. And I think it's far more likely that the defendant, once released from prison, is going to fall back on old networks and old habits than immediately make positive contributions to society, unless there's some sort of structure or system in place where he can be supervised or monitored during this difficult transition period. Therefore, I humbly request the court to consider the two aspects of the sentence, supervised release along with incarceration, to be served consecutively instead of concurrently. Thank you very much for your time, Your Honor.
Thank you. And that's all, Ms. Bauer?
Yes.
All right. Mr. Schmidt, argument and sentencing recommendation.
Thank you, Judge. As the court recalls, this is a joint recommendation of 3 years initial confinement in the Wisconsin state prison system, which will be followed by 3 years extended supervision, which would be by the Department of Corrections. They come one after another, and that the agreement will be that in the 5 burglaries, they will be concurrent to each other, but they will be consecutive to Burnett County 23 CF 99. So the total sentence, the court follows it today, would be structured with 5 years initial confinement in actual prison, followed by 5 years extended supervision. Going a little more detail on that, because I think there's some confusion from the victims about how all that worked.
This is where sentencing gets real math heavy, and victims often get confused, understandably. The DA is describing a structure where some cases run concurrent at the same time, but this case stacks consecutive to a prior case, meaning it adds on. That's why the 2 years idea doesn't match what's actually being asked. Also notice the prosecution storyline: drug possession, lying to police, theft, burglaries. That's escalation. So here's the debate: punishment for deterrence or rehab because the pattern started later in life, meaning change is still possible. What do you think matters more here, past pattern or future potential?
And what that recommendation is. The court knows Robert English pretty well, and the reason why we don't have a PSI is we just did a sentencing after revocation back in October. The court already had a rev packet that went over his history. The court knows that Robert English is a 40-year-old man who had no criminal history until about 7 years ago. In 2018, Mr. English's history started. To recap that again, in 2018 in Washington, in Minnesota, he got a gross misdemeanor drug possession, which is Wisconsin's equivalent of a misdemeanor. 2018, another Washington drug possession. 2020 in Anoka County, another drug possession. 2021, Chisago County, obstructing police. 2022, Pine County, giving police a false name. 2022, Burnett County, disorderly conduct. 2023, Sherburne County, felony drug possession. That was one of his first felonies, the other being the 2023 Burnett County, receiving stolen property. The reason I bring that up is because what this reflects is that Robert English is a person who developed a drug problem that grew into a lying to police problem that grew into a thievery problem over the course of the past 7 years. The fact that it happened in middle age shows that he is capable of being law-abiding as he was prior to 2018. If the court had, a magic wand and it could make things a certain way, it could just turn back the clock to 2018 and we'd have a law-abiding citizen. I don't know what changed in his life that made that different. I point that out to point out that this is not a person who's been doing crimes since he was a child or a young adult like we frequently do with the severe recidivists. It's also a person where you can trace the clear line from substance abuse to what he's doing now, the thievery. It was also evident in the actual evidence of the case. The court knows we dumped a lot of social media, a lot of Facebook, a lot of discussions about drugs in association with the stealing. At sentencing, the court has to first consider probation. Probation is not appropriate in this case because this offense happened while the offender was absconding from probation on the receiving stolen property from the Burnett County 23 case. It would depreciate the seriousness of the offense to place him on probation again because he was on probation when this happened and he was actively absconding from it. It wouldn't even make rational sense aside from the depreciating the seriousness of the offense. As it relates to gravity of the offense, that's where we get into why this case requires incarceration, and more specifically, why it requires a prison sentence rather than a jail sentence. A jail sentence would be for like a first-time offender. Maybe they do one thievery offense and one that's not burglary. This is a case with 5 burglaries, numerous victims, more than 5 victims, because some of these residences were owned by multiple people or by a trust that's connected to multiple people. And the court's heard some impact of this and has some idea of the impact from this from the restitution hearing. I'm glad that MM talked about something that is never really appreciated in the restitution requests, which is the sentimental value to some items. They can never be replaced. Say, I have a phone that could be replaced. I could buy a new model, but if I got it from like my mother who's passed away now, I could never get that phone again. It's gone forever. And that's something that really strikes to why burglary needs to be treated very seriously. I'll address that on 2 main fronts. One, as the victims allude to, and as this court has heard time and time again, not just from these victims, but other victims we've had in burglaries, when someone's been in your home and you come in and you see that things have been moved or they've been taken, or even if you're just aware of it. I know myself, somebody's been into my home before and they didn't take anything, but it really distressed my wife in a great deal. That sort of loss of security and privacy and sense can be very impactful on people. It has a strong psychological effect that really goes to the heart of why this offense needs more punishment, why it has a high gravity towards it, and the seriousness of it. The second, which I'm really glad the Wisconsin legislature did reason, is they recognize that burglary, even though there's not an element of causing harm to people, is categorized as a crime of violence. The federal system has long considered burglary a crime of violence, and the reason why the federals have and why the Wisconsin state legislature recently categorized it with the last constitutional amendment is because burglary of a home is going into a place that's not yours. You don't know who's coming and going. You don't know when they're coming and going. And being in the home, the place of last refuge, it has the highest chance of causing a violent confrontation that could cause harm either to the residents or to the person doing the burglary. It's a crime that isn't just of theft, isn't just a property crime of taking from people. It's also a crime of risk. That's why its penalty is higher than theft. It takes into account that risk element to it. With that said, that's why we know that this has to be a prison case, even though, yes, Mr. English has 8 prior convictions. The court's heard the vast majority of those convictions. All crimes are serious, but when we're grading offenses, simple drug possession is generally not considered a very serious offense. Lying to police is more serious, but none of those really compare to what happened in 23 with the receiving stolen property, and now with the 24 into 25, these burglaries. That is why we know it cannot be a jail sentence. It cannot be less than a year. It needs to be a prison sentence for those reasons. So we're talking about prison. To that end, I have to talk as well about what Mr. English was on supervision for from the 2023 case. So just to briefly summarize that case, that was a case where the police went to where he was, saw that he had stolen property there. He had the key on his person. He was at his mother's house and said that he didn't take it. He said that Kenneth Ochterling took it. Kenneth Ochterling had been wondering about burglarizing around the area. This offense involves Mr. English working with Stephanie Ochterling, who is Kenneth Ochterling's sister. Numerous items of their property was found where Robert and Stephanie reside. Stephanie's DNA was at 3 of the crime scenes, and Kenneth Ochterling had some connection to as well. So he didn't change the place. All these burglaries occurred around the same place within a short distance of Robert English's mother's place where he lives. People, he's associating with the same people, Stephanie Ochterling, Kenneth Ochterling, and doing the same behaviors, really an escalated form of behavior. This is associated with what the court frequently calls in its sentencing hearings and what the law calls a pattern of undesirable behavior. It's actually worse than that in this situation, since before what was received in stolen property from Kenneth Ochterling, now is burglaries with Stephanie Ochterling and Kenneth Ochterling associated in some other manner. That shows worse than a pattern of undesirable behavior. It shows escalation on a previous pattern. That is another reason why we're coming to the court and asking for a significant prison sentence on this case in relation to what this offender's history has been. Aside from that sentencing the court did in October, I don't believe he's ever actually been to prison before. I think the closest he's gotten is his only felony in Minnesota. They did a weird sentence where they gave him 1 year and a day, but said it only counts as 1 year for the actual time. They tried to manipulate their own Minnesota system to not send him to prison, as far as I can tell. And that brings me finally to the last thing I wanted to address in this. One of the victims talked about he's been the victim of theft 3 times in our county. 2 of the times has been in his home. I think the court knows something I've been referring to in past burglary cases in our county, and that if you look at CCAP statistics, the rate of burglary in our county is much higher than the rate of burglary in Wisconsin as a whole. It's a problem in our county because of the rural nature, because many of the occupants leave for a long period of time, and because of the impoverishment that exists in our county. Those 3 things go together and cause as a problem. What that means is we have an extra need in Burnett County to generally deter other offenders of this specific behavior. You go to other counties, people aren't necessarily getting prison in every single burglary case like they are in our county, like they are, I'm asking you to today. That is because that need is so specific and a need in our community to prevent this behavior, to stop people from coming here from other areas and saying, hey, this is a place where maybe I won't get as high a penalty. We want to prevent that. We need the prison in this community because it's such a specific problem to our community. We need to generally deter it. So I think that what this represents, this recommendation, 3 and 3 out consecutive to the 2 and 2 out of the previous case in Burnett County, I think it represents the best chance Robert English has to get rehabilitation in a setting that he won't be a danger, in a confined setting. He couldn't do it while on probation because he just absconded from probation. Probation's worthless if the offender's just not even doing it. Doing it in a confined setting is honestly the best shot he has. ERP is a good shot for him. Depending on how that goes someday in the future, when all this is done with the incarceration time, drug court would be a good idea for this kind of offender. He's not been convicted of a crime of violence and he's not a violent offender. Doing inpatient or some sort of like program in prison is a good idea for this person. That's something I think the court should really look at on this. I think the 5-year confinement is an appropriate amount when you total them together, the 3 and 3 out consecutive, the 2 and 2 out. Yes, that's a lot of time for this offender. His criminal history only goes back 7 years, and I'm saying, hey, send him to prison, initial confinement 5 years. But I think given the level of harm, the extent of it, and the emotional harm that I think the court probably heard from the victims today, that's necessary in this case. I think that for this offender, it is a long prison sentence, but because it's 5 burglaries and the impact on the victims and the need to generally deter this behavior, in particular in our county, this sentence is the right sentence, especially when we consider what he was on supervision for, very similar behavior. Thank you.
Thank you. Mr. Reed?
Thank you, Your Honor. I am here with Mr. English, Robert. He is here for sentencing on 5 burglaries. He's here taking accountability, and he's here also to try to make things better for the victims of these cases. We did file a sentencing memorandum, I believe, on the 10th of this month. In that memo, I think it outlines programs that he can take advantage of and use in the Wisconsin prison system. But I'll get to that, Your Honor. As the court knows, it must utilize the Gallion factors in fashioning a sentence. We believe first that we all agree that these are very serious. Burglaries are as the state has outlined, very serious. They're emotional. They're very serious crimes. I believe the community is better protected if Mr. English also is taken out of the community in the Wisconsin prison system and on extended supervision, learning better coping skills, vocational skills, pay the restitution, and be a better person in this community. I also believe that the rehabilitation here is also part of this sentence. We believe that the sentencing memorandum outlines specific vocational and mental health programming that can happen in the Department of Corrections, the Wisconsin prison system, that Robert can be offered vocational, mental health, criminal thinking, and life skills training while in the Wisconsin prison system. We believe that with these interventions in custody, incarcerated, that Robert can be a better person in this community. Part of this sentence, I believe, takes into account Robert's want to pay restitution. He has worked before, as outlined in the memo. He can work once he gets out of the prison system and while in the prison system, Your Honor. And we believe that this sentence helps work towards putting the victims or making them whole, putting them in or trying his best to put them where they were before these crimes were committed, while also getting other skills to not be here again, working on the mental health, working on the substance abuse issue, working on the life skills to be a better person in the community, be a better family member, be a better friend, so that this doesn't happen again. I think the things the state outlined in its argument about how it affects people very close, very emotionally, the invasion part of it, Your Honor. Robert understands that, and I anticipate that he's going to be speaking so he can speak to how he feels, but he understands the effect on the community that he's had. And I understand there may be some concern that this isn't enough. I would join in the state arguing that the galleon factors, weighing the interests that that case requires, that the sentence that we're joining is appropriate. It helps the community. It helps Mr. English. And I believe it'll make Mr. English and the community a better place if you follow the joint recommendation, Your Honor. So that's what we're asking for you to do. Thank you.
Thank you.
So she's gonna ask. Yeah. She says, go ahead.
All right, Mr. English, I'm going to give you an opportunity right now to make a statement if you wish. You can tell me anything about this case, about any remorse you may have, any feelings you may have. You do not have to make a statement if you wish to.
Yes, I'll just like to apologize to the victims for my actions. There's no excuses for what I done. I'm very, very sorry for my actions. I plan on getting help while I'm in custody for mental health, take these courses like car mechanics and stuff like that, because that's in my family. Plan on doing that so when I get out, I can make them whole, or try to best I can. I'd just like to apologize for my actions again. I'm very sorry, guys.
Thank you.
I'm very, very sorry.
Thank you. Mr. English, this has been, I think, the third time you've been in front of me for a sentencing. Not too long ago, in your other case, I did sentence you to 2 years of initial confinement and 2 years of extended supervision in prison. And that was from a 2023 case. And that was due to various reasons, but the fact that you just didn't get it and you continued down that criminal track. I've heard the arguments of both the state and the defense, and as stated, I'm aware I'm pretty aware of you and your information. What I'm not, I ask questions, you provide the information, and you've been pretty open. In sentencing an individual, the court has to look at certain factors. One is the nature and the gravity of the offense. How serious is this case or these incidents, these actions? Secondly, I have to look at your character, your past criminal record, and any rehabilitative needs that you have. Third, I have to look at needing to protect the public. There are other outlying factors that the court looks at as well. That would be the effect on the victims. That would be an undesirable behavior pattern. That would be your culpability, your age, your education, your history, and deterrence. And that would be general deterrence to generally deter others from being in that chair in orange, from doing the same thing or similar things, or specific deterrence to specifically deter you from committing crimes like this or any crimes at all, especially in this county.
Here comes a key legal concept. Restitution is financial, but the judge is making it clear that it's not the same as making someone whole. The number, $32,344.84, is the paper value of items, but the court is openly recognizing sentimental value and psychological damage, which victims almost never feel is fully counted. And did you catch the judge's point? Burglaries don't just hit one family, they ripple into community trust, tourism, and local business survival in a rural county. So let me ask you, if your safe place got violated, would money ever truly fix it, or would you want the court to send a bigger message?
First, I want to know, do you stipulate to the restitution in the amount of $32,344.84?
Yes.
And I heard from your attorney that you want to pay back the restitution.
Yes.
You want to pay back this money that these items have been valued at. Restitution is to try and make the victims whole, again, as whole as the system can. As you heard from MM, he's not ever going to be whole from this situation because you and possibly others took things from him that had more value than what can be placed upon paper. Sentimental value, things that mean a lot to him, things that he could have passed on to his children or grandchildren or nieces or nephews. But now he's unable to do that. So in some cases, the system is not able to make the victims whole. And that's just with the property that was taken. Again, as you've heard, that this is something that not only affects people financially, it affects them emotionally, mentally, their whole well-being, because you have invaded their space, their castle, or their cottage away from their castle. I'm going to guess. I don't know. I have not looked at their address, but I'm going to guess from hearing from the two that we did that they originally are from Minnesota or something of that nature, some other state, and they've relocated here. They've come to Burnett County for peace and solitude and all the beauty that they believed at the time when they bought their house and cabins and things existed. I don't doubt that MM has been a subject of burglary, a victim of burglary, at least 3 times. That's sad to me as a human. It's sad to me as a lifetime resident of Burnett County. And it's sad to me as a judicial official who sits in this chair, who is to oversee the law and to ensure that not only are defendants given the ability to have rehabilitation, to improve themselves, because that's the ultimate goal, is to help people not be in that situation again so they don't commit crimes. But it's also sitting here, my job is not only rehabilitation or to look at those aspects, it's punishment as well. Punishment. And Mr. Schmidt stated in his argument that Burnett County has been hit hard, and that's what people from other states that want to come here and enjoy our beautiful lakes and our wilderness and all of those things, they don't know, they don't understand, because it's so beautiful and their ears are closed, but their eyes are open to what they see, and they don't understand what has occurred in this county. At least, I know, at least in the 8.5 years I've been on this chair, and a lot further back in time. We've had a lot of burglaries that have occurred. And Mr. Schmidt made a good point of, if we don't have punishment for crimes like this, it's going to continue to happen. Because we need deterrence, because the court looks at that. Not only specific deterrence to try and deter you, Mr. English, from committing more crimes and crimes like this, but general deterrence to try and prevent or to deter others in the community or outside of our community from coming into our community and committing these types of crimes. Because it doesn't just hurt the specific victims of the crime, it hurts everybody. It hurts everybody. And I'm going to throw out there that this is a county where we rely heavily on tourism. We are one of the poorest counties in the state of Wisconsin, one of the poorest. Our county survives on tourism and from others who like to come here and spend their weekends and or their time off from work and enjoy our county. Now, if we have a county known as a very criminogenic county, if we are known for having violent crimes such as burglaries in our county, that will deter people from wanting to come here. That will significantly impact everybody in this county. All of the small businesses rely on not only the people locally, but we heavily rely on others who come into our county to enjoy it. And Mr. English, I unfortunately do not have a strong history with you, even though this is your third conviction and sentencing in front of me. I don't have a strong history with you and your convictions to know if you are able or want to have the steps and move with rehabilitation. I do have that 2023 case in which I did sentence you to prison because you didn't. You absconded for a long period of time. You continued to commit offenses while on probation. It showed me that you were not taking your 2023 or whenever I convicted you, if it was 2024, I'm not entirely sure, but I can look right now. August 7th, 2023 is when I sentenced you and placed you on probation, giving you that chance because, again, things that I said at the last sentencing hearing, I was very lenient and open to you because you had expressed to me very vigorously that you wanted to change your ways and change your habits. You wanted to change your life, but then you didn't. You continued down that path. You have to change your habits You have to change your associates, the people you hang out with, that you spend your time with. You have to change yourself to be able to significantly improve your life. You have to do more than just modify or change your personal habits. You have to actively make an active effort to surround yourself with people who have positive influences, who can have a positive change on you, so that you can align yourself to have better goals, to have a job, to not live in your truck, to be able to pay your bills, to be able to have a stable life. I want to believe, Mr. English, that you want to change. I want to believe that you want to be stable and not go down this path any further. You apologize to the victims. They can accept it or not accept it, whether it's sincere or not sincere. I don't know. If it's true remorse, then this will have a significant impact on you, and you will look seriously at changing your life. If it was said because you're just sorry because now you're in this position where you're going to go to prison for even longer of a period of time, and now you're looking at you, you're not the victim.
I know I'm not.
I don't know your criminal history in Minnesota. I don't know all of the convictions you've had, and I know that you were supposed to go to prison, you didn't, but I know, I'm so sorry. I know Minnesota justice system, not really great. Not great. You can't change the system. You can't change the world. You can't change people unless people understand that there's ramifications to their actions and their conduct. It's not sentencing you to prison and then having you sit in prison for 86 days when you were sentenced to 2 years. That's not how it should work. The great thing about Wisconsin prison system is that it's truth in sentencing. If I sentence you to 5 years, you sit 5 years unless I give you the permission and ability to engage in the early release programs. Truth in sentencing. Mr. Schmidt is correct that we have to first look at probation and those types of things. We all agree this is not a probationary case. This is more serious than that. It is a burglary case. It is identified as a violent offense under Wisconsin law. So the court has to look at what amount of time, prison time, is appropriate in a case such as this, and looking at your history that I'm aware of, and looking at your rehabilitative prospects, and taking into account the effect of the victims and deterrence. What is an appropriate length of time in prison? If I order confinement, it has to be at the minimum amount, which is consistent to protect the public, to look at the gravity of the offense, and to look at your rehabilitative needs. Now, at the last sentencing, where I did sentence you to prison, I did indicate you could engage in the substance abuse program. You have substance abuse issues. I don't know the extent of them. I don't know if you're completely honest with the court or even honest with yourself. The extent of your addictions. That's where you're going to start to heal, is when you are honest with yourself. You can lie to everybody, but when you lie to yourself, there's no ability to change. You did accept responsibility, and you have pled guilty to 5 serious burglary offenses. And you did agree and stipulate to a joint agreement for 3 years of initial confinement and 3 years of extended supervision consecutive to that other prison sentence. That's positive on your side. As the state indicated, I also have to look at your history and that there does show and appear to be an undesirable behavior pattern. This is something that you've engaged in. Granted, not for a very lengthy time, since 2018, that's when your criminal history started. But from there, that's essentially what has happened. And that's why you're in this seat right now. And I'm just going to add, and I'm just going to say that having your mom, putting your mom in the middle of all of this, I don't know your relationship with her, but storing the property, the stolen property at her house, and I understand the issues that she has and how you've grown up. But that's not right, and that's disrespectful, and quite honestly, it's something that you should have thought about before. You are agreeing to pay back the restitution, but again, it's not something that can be, even if the money is paid back in full, it's not something that you can help heal the victims. And $32,000, I'm going to be honest, is a lot of money to you. I don't know the last time you've held a consistent and stable job. It's been years. And I don't believe you have, if I'm recalling correctly, that you have any education outside of high school. Mm-hmm. No. And so I don't know of the skills that you have to be able to make enough money to be able to pay back the victims. And again, that's where the victims become victimized again. In looking at the seriousness of this case and in looking at needing to protect the public, and that is the public as a whole, as well as the victims present here today. I do believe that a stronger sentence is appropriate, and that's because I am going to make you eligible for the early release program. That gives you the ability to go through substance abuse treatment. It gives you the ability to learn different ways of thinking and to perhaps change that criminal thinking. So what the court is going to do I'm going to sentence you to 5 years of initial confinement, 5 years of extended supervision, consecutive to 23 CF 99. And I'm going to do that on all counts. But I am going to make them concurrent to each other, not because I don't believe that they don't deserve separate sentences, because they are each separate incidents, separate crimes, separate days. But because I have increased the amount of time than argued for, and the reason why I am not following the recommendation is because I do think that this is very serious. This does fall in the violent crime category because this isn't your first time engaging in this, and you're shaking your head up and down. You understand, yes, that this does deserve punishment. And it needs to deter others, not specifically just you, but it does need to deter others. as well. So the court is going to make you ineligible for the challenge incarceration program. I believe you're aged out, but I will make you eligible for the substance abuse program. I'm going to order that you owe restitution to the victims in the amount of $32,344.84. I'm going to order $518 for the first offense in court costs and fees, $250 for each other conviction. Conditions of probation or extended supervision, gainful employment, no illegal drugs, substances, or paraphernalia, no alcohol, no bars, taverns, liquor stores, or establishments that have the primary purpose for the sale or the service of alcohol. I'm ordering that you undergo and complete a criminal thinking program. Absolutely no contact with any of the victims, their residences, or any of their cabins or vacation homes. No firearms for life, no voting in any election until your civil rights are restored. And I am ordering no contact with Kenneth Achterling and Stephanie Achterling. No contact with anyone who is on felony probation or felony supervision without your agent's approval. I'm also going to order a mental health evaluation, whether or not that occurs in prison or outside, and to follow all of the requirements and recommendations thereafter. I believe that a sentence less than this would unduly depreciate the seriousness of the offenses, taking into account the public interest and protection of the public and the needs, would unduly depreciate the seriousness. I'm ordering your DNA. You must provide that. This, I believe, is not a crime that you can have it expunged from the system, but you can look into it if you wish through a written letter to the Department of Justice. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is ordering that all restitution, surcharges, court costs, and fines be collected as a percentage to be determined by the Department of Corrections to be reasonable while you are in state prison, and it is a condition of extended supervision. The Department of Corrections shall collect all of the sums. Once you are released from your prison incarceration and you are on extended supervision, you will have at minimum $250 a month in restitution. You will be engaging in restitution court quarterly. If you cannot afford the $250 a month, once you're released on extended supervision, you can file a motion with the court for a financial review hearing, and I will go over all of that information. You will be required to have gainful employment or to do work searches and provide proof to the court. I'm going to tell you that sometimes when the court has financial review hearings, individuals think that their payment will go down. I have actually raised it in some circumstances.
So here's the professional wrap. The court weighed the classic sentencing factors: gravity of the offense, character and record, protection of the public, impact on victims, and deterrence, and ultimately went beyond the joint recommendation. The judge imposed 5 years initial confinement plus 5 years extended supervision, consecutive to the prior case, while making counts concurrent with each other. The court also locked in major conditions: restitution payments, no contact with victims, substance abuse programming eligibility, mental health evaluation, and strict supervision rules. Bigger picture? This ruling signals a shift from second chances to community protection and deterrence, especially in a county facing repeat burglary patterns. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I believe that covers everything, Mr. Schmidt.
Nothing further from me.
Jail credit. How much jail credit does he have?
Oh, thank you, Your Honor. Due to the structure of the sentence, he doesn't have any.
All right. What am I missing, Mr. Reed?
Nothing, Your Honor, from the defense.
All right. Then we are